Kelsen, in this case, was the proprietor of a number of tobacco stores around London, and this one was in Islington, just to the north of the city centre. He had leased a single-floor shop for use as a tobacconist's. The next building was somewhat taller, and so the side of that building was ideal for advertising. However, the building itself was built up flush to the property boundary, so any sign which was erected against the wall would inevitably project out over the roof of Kelsen's shop, even if only by a few inches. The company making Players brand tobacco agreed to pay the building owner next door £30 a year to have their advertising sign against the outside wall of the building. They wrote to the owner of Kelsen's building, remember he only had a lease, and sought permission. They said that they had no objection. Nobody asked Kelsen what he thought. Initially he tolerated the sign. After all, one imagines that a big sign for a tobacco company wouldn't have done any harm drumming up business for his tobacco shop. But eventually there was a dispute, and Kelsen demanded that the sign be removed because it was a trespass upon his property. The judge agreed, quoting an earlier case called Gifford and Dent, in which it had been said in a similar fact scenario that the plaintiffs were tenants of the forecourt and were accordingly tenants of the space above the forecourt usque ad coelum. It seemed to him that the projection was clearly a trespass upon the property of the plaintiffs. Usque ad coelum is Latin for up to the heavens. In other words, the judge, Justice McNair, found that as the tenant of the land, Kelsen was also tenant of the column of air above the land, right up to the heavens. As a result, the sign projecting over his shop was a trespass, and he was entitled to an injunction ordering its removal. Careful though, a more recent case called Baron Bernstein of Lee against Skyviews in general found that a person's rights over their land extended upward only so far as would reasonably affect their use of the land. However, both of these cases are consistent on one point. A person's right to protection from trespass against their land are not limited to the land itself at ground level.